This program is a Warren Steibel production in association with South Carolina ETV. Funding for Firing Line is made possible by a major grant from the John M. Olin Foundation, Incorporated. Additional support is provided by the Annenberg Foundation and the Friends of Firing Line.
In 1992, on an island offshore from Charleston, South Carolina, Mr. Lucas set out to develop two plots of land he had bought, one reserved for his own new home, the second to sell to the highest bidder. The property lay more than 300 feet from the waterfront and so was safe from current environmental protections. But when he began to build, he was told that the regulations had been changed, that the protections extended a further distance past his own property line, so he sued. He cited the Fifth Amendment to the Constitution, which specifies that the government cannot, quote, take a citizen's property without compensation, when the so-called takings laws, whence the so-called taking laws are cropping up everywhere. Two vigorous South Carolinians are with us to explore the implications of the Lucas case and to contend on what roughly can be thought of as a quarrel between environmentalists and property rights primacy advocates. Neil Robinson is a practicing attorney in a distinguished firm, and he is much involved in real estate development laws. He's a graduate of the University of Clemson and the University of South Carolina, and an advocate of the Private Property Rights Act, recently introduced in the South Carolina General Assembly. Alex Sanders, who is welcome back on Firing Line, also graduated from the University of South Carolina and from the University of Virginia. He taught law at his alma mater and at the Harvard Law School before entering the judiciary, where he served as chief judge of the South Carolina Court of Appeals. 5 years ago, he resigned to become the 19th president of the College of Charleston. And let me begin by asking Mr. Robinson briefly, what did the Supreme Court rule in the matter of poor Mr. Lucas?
Well, poor Mr. Lucas, who played basketball for the University of South Carolina, was also one of the developers of the property, which he purchased, 2 lots. The case went up on the takings clause, Fifth Amendment taking clause, as you mentioned, Mr. Buckley, and the Supreme Court held that he had indeed been deprived of all economic use of his property, and proving that point alone was entitled to recovery or relief. But the Supreme Court sent it back to the South Carolina Supreme Court for further proceedings, because the South Carolina court had held that because of nuisance laws, the fact that he had been deprived of his property was not determinative of compensation, and that building on the beach was equated to being a nuisance, and therefore Mr. Lucas was not entitled to recovered monetary damages. The U.S. Supreme Court disagreed with that and sent it back for further determination.
Well, let me ask this question, which I think would occur to most of us. Does the takings clause in the Constitution require compensation if you take the whole thing, or are there gradations of taking? And is this what we're talking about in Lucas' case?
Well, I think that's, you cut right to the heart of the matter. The Supreme Court has said that if indeed you take all economic use of property, that is a per se taking that entitles one to compensation. It's the gradations that cause the problem. In most cases, property has some residual value. And even in the Lucas case, for example, the Supreme Court left the question open as to what they would do if, in fact, the property had been damaged 90%. Would they treat it as a 100% taking of the 90% part, or would they treat it simply as a diminution in value of the whole? And it's that problem that we see in most of the Supreme Court cases.
Well, they could always ask Judge Sanders what the solution to that is.
I'd be glad to resolve that, except I've taken an oath not to be a judge anymore.
Well, but you haven't taken an oath not to opine.
No, that's true. That's true. I still have those First Amendment rights accorded to even common criminals.
Well, what do you have to contribute to make up for Mr. Robinson's ignorance?
Well, Mr. Robinson is not ignorant, and as a matter of fact, he's more knowledgeable about the subject than I will be. He has gone so far as to read these cases, something I haven't done since I was a judge. But
that's more than the Supreme Court does, isn't it?
well, I don't know. I've never been there. But the serious point is this. It seems to me that the concept of compensating a property owner because his property has been diminished in value, or else removing whatever impediment it is to the development he would like to engage in, that very concept has at least two problems, one practical, the other legal. The practical problem, which is something people are probably more interested in, I could illustrate by example. I own about 50 acres of salt marsh on Highway 17 between the highway and the ocean. As nearly as I can recall, I paid about 50 cents an acre for that salt marsh. And as best I can determine, it's not worth more than 50 cents an acre now. Because although it is mine, what can I do with it except look at it? Mm-hmm. Well, it just appealed to me, and who wouldn't buy 50 acres, you know, for $25, right? Of anything, right? I took a sort of a long view of that. Also, at the time I bought it, there wasn't any absolute prohibition against filling it in. So I thought maybe if I bought it, then nobody would fill it in because it belonged to me. It's worth $25. Wasn't all that altruistic a decision, but I can't do anything with that property except look at it, which is the same thing you can do with it, even though you don't own it. Pay a little bit of taxes on it, that's my great privilege. But if I could fill that property in, and but for the dreaded regulation of law, I could fill it in. If I could fill that property in, it would be worth conservatively $10 million. Now, as a practical matter, does anybody believe the government is going to pay me $10 million for something I paid $25 for? Of course not. If they set that precedent, the burden would overwhelm not only the state government, but the federal government right in South Carolina.
Well, is anybody arguing, Mr. Robinson, that he should be paid $10 million?
Not at all.
Why not?
Well, I think when you bought the land, you bought $25 worth of land. Your investment backed expectations at the time were that you were going to have $25 worth of land.
Well, that's true, but your legislation, the legislation that you are supporting in the General Assembly, requires compensation for diminished value, doesn't it?
That's correct.
How can
Why
you
wouldn't I
diminish
get the
$25?
$10
How can you diminish $25?
Well, no. That's a popular misconception. Things are not worth what people pay for them. Things are worth what other people will pay for them. And I've got a piece of property worth $10 million if I could fill it in. And the only reason I can't is because of this damn government, you see, that's interfering with my life and taking my private property rights as a citizen.
I don't think that James Madison had
that
in mind, did he? You're talking about the potential value of a piece of property.
Market value is what the legislation is based on.
Well, you can say if you put the Eiffel Tower on it, it could be worth $20 million.
No, I'm not suggesting that it has a $10 million value, or maybe that's slightly exaggerated, a $3 million value, because I am going to fill it in, and that's comparable to putting the Eiffel Tower on it. It has that value because I would have the right to fill it in were it not for this regulation. Now, but let me tell you about the legal argument too, because that's less exaggerated. The courts have always represented, have always allowed so-called takings to protect public health and safety. That's a part of the police powers of the court, which have to be balanced against the Fifth Amendment.
But we're not talking about taking, we're talking about compensation, right? Nobody doubts eminent domain or whatever.
But the question is this: does the government, which has regulated a piece of land have to pay for the diminished property value, or simply retreat from the regulations. That's the way it's cast by the Supreme Court and by the pending legislation. But the Supreme Court has always recognized, and there's a seminal case involving some elm trees, I forgot the name of, but that the government can, in effect, take private property without compensation to protect public health and safety. The tree case puts it in perspective. This is what
we're arguing about, isn't it? Did Mr. Lucas at any point petition? Now, we now know that since then he has in fact sold the property, hasn't he?
The state bought the property from Mr. Lucas, and then, of course, in its infinite wisdom, granted an exception, issued a development permit, and sold the lots to somebody to build homes on.
I won't defend that one.
At a profit?
Not at a profit.
Not at a profit. Let's focus very carefully here. Your point is that in order to further the commonweal, the state can take action which has the effect of reducing the value of a property.
Yeah, but after the Berlin Wall fell, I quit saying about the commonweal. That doesn't seem to fit anymore.
Well,
it's public health and safety.
What's that?
Public health and safety.
Well, some say potato, some say potato. What is the Supreme Court? Here's what Scalia said. Law should not take the position that there is nothing in between taking a property and otherwise affecting it. Now, Scalia, in effect, says to South Carolina, sharpen your distinctions here and tell us what you are up to and whether you owe Lucas something that you didn't pay Lucas. Now, is that your understanding?
Well, that's what we're trying to do. We're trying to take the situation, the legislation we've introduced would take the developer who owns a $10 million piece of property that has its value reduced to $25 by regulation. For example, on your marsh, suppose it had been high ground that was developable and it was worth $10 million and you paid $10 million. And the state passed a regulation that said, we don't want anything built between the highway and the ocean so everybody riding up and down the road can see the beautiful sights. I suspect in that case you would have a legitimate complaint.
Well, I suspect so too if they did it so people could see the beautiful sights, but suppose they did it to protect considerations of public safety and health. Yeah. You know, when the environmental movement was in its infancy, people looked at the cause as one of keeping poisons out of the air and water, things that would harm you immediately, poisonous gases, toxic waste. And that's why the enforcing agencies were all called health departments. It's the health department that was in charge of that. Now those agencies are called Departments of Health and Environmental Control because we have matured. And we recognize just how something doesn't make you sick today, still the life of the planet could be put at stake in the long run.
Well, is it left as a political or a judicial problem that there should be a procedure when somebody decides to move the protected part of a property from 300 feet to 400 feet, affecting the value of that marginal 100 feet? Is this the mandate of the Supreme Court handed to the legislature in Columbia, or is it a mandate to the judiciary in South Carolina?
Well, from my point of view, in the Lucas case, simply the Supreme Court in South Carolina picked the wrong avenue to rule on the case. They decided to address it on the merits. They addressed it on the theory of nuisance instead of on whether the case was ripe for decision. In fact, during the pendency of the case, before they handed down their opinion, the legislature amended the act which provided for the issuance of an exception or a special permit. And instead of kicking it back down for further proceedings in light of that amendment, the court chose to go ahead and ruled on it on the basis of nuisance, and that's why it got kicked back. And I think the U.S. Supreme Court, in a sense, was slapping the hand of the South Carolina Supreme Court, saying, you know, you picked the wrong law to come up on.
Well, now, I understand 25 states now have takings laws. What precipitated the codification of those laws?
As of 30 minutes ago, 25 states. I wouldn't be surprised if there aren't more now. There's a real effort and a movement afoot in this country to take back some of the property rights that have been eroded over several decades of regulatory environment that have swung the pendulum so far that people are mad as hell. People are saying, you know, enough of this. They're frustrated with the time that it takes to get a permit, with the conditions they have to put up with. And some of the agencies themselves have taken a certain attitude about people's property that they have control over your property. And I think people want that control back.
Let me venture this slightly different perspective.
Sure.
For as long as I have been in this business, which is more than 40 years, people have been mad as hell about it. It just depends on whose ox is being gored as to how mad they are. I remember a fellow called me one time in the 70s when I was practicing law. He's a very prominent Columbia businessman, a Calvin Coolidge Republican, and he wanted to hire me to keep some people from building a high-rise condominium next to his beach house. And of course, I was glad to have a paying customer. They were few and far between. On my side of the environment, anyway, I was on the side of the angels. But I couldn't resist asking him a rude question. I said, you know, I'm mistaken. I always thought you were the kind of a fellow who believed that a man, by God, ought to do what he wants to with his own land. He said, I'll tell you something, son. When this case is over, I'm going back to believing that. And that pretty much personifies where we are. But these bureaucrats that are so roundly criticized, in my experience, have been the most politicized bureaucrats that I've ever observed. And they invariably report to elected officials and therefore are quite sensitive to the sweeps of change to democracy. I think the answer to the whole thing is at the ballot box. Whatever your perspective is.
Well, but you have to have a consolidated philosophical position, surely. Oliver Wendell Holmes, as I remember, was once asked to define a fanatic. He said, look, everybody agrees that if you have a house, you own the air above your roof, so that, for instance, your neighbor couldn't extend a wing over your roof. But the fanatic believes that the shaft of air above his house extends on into the galaxies, such that no child can fly a kite without getting permission. That's a fanatic. Now, we discard or attempt to the aggressions of the fanatic, but we're still left wondering whether there is an injustice of the kind the Fifth Amendment sought to oppose when a political body decides when A decides what B shall give to C, in this situation, how much to diminish the value of your property.
Well, Mr. Robinson, and I'm sure you agree with me that if a regulation of land use resulted in property being of no value and no use, and at the same time the regulation was unnecessary to protect public health and safety, by the way, something that Justice Scalia in his eloquent opinion didn't address, then of course the Fifth Amendment would be evoked.
But the point is, you got to go beyond that, is your position.
On a regulatory taking, I think so. The Supreme Court routinely, if it's a physical appropriation or a physical invasion of property, if it's 1 square foot, you get paid. But on a regulatory taking, you have to rise to the level right now of complete taking.
In the case of Lucas, was that regulatory or legislative?
That was regulatory. That was the Beachfront Management Act that was enacted that provided the setback that actually took all of his lot.
So a commission can say, tomorrow it's going to be 600 feet, not 300 feet.
Absolutely.
And
well, the legislature would have to do that, and the commission would enforce it.
I mean, the commission recommends to the legislature that they increase the protection from X to Y.
That's correct.
Is it acknowledged by the legal community that there is that middle point in which protest ought to be constitutionally protected?
Sure. The question is, where do you draw the line? I just drew my line, and Mr. Robinson's line was especially ahead of mine. Let me just tell you about this.
You said let politics decide it, right?
Well, and then I would say what I think politics ought to say, and what the result of those politics ought to be is that if a person's property is regulated to the point where it has no use whatsoever, and if public health and safety considerations are not demanded, then the person should be compensated for property, but not otherwise. You remember the Elm Tree case? I have forgotten the Elm Tree case. It's coming back to me though slowly.
I hope he remembers it. If
I barely remember being a judge, but there were a town as I envisioned it in quintessential New England that had elm trees on every street. Probably had a street named Elm Street. And the trees became affected with some disease.
Dutch elm.
Dutch elm disease, you got it. And I knew you would know. And so what the town did in an effort to thwart this rampaging blight on their vegetation, they came in and cut down all the elm trees. And some of those trees were on private property. And some of the trees on private property did not have the disease, but were just potential carriers of it. And the United States Supreme Court said no compensation. You took these people's trees, that's a property right, but public health and safety.
Well, that's just the right of quarantine. That's pretty ancient, isn't it?
Well, now, yes, but how about this?
Defend me.
How about this? How about if an acre of salt marsh, it can be demonstrated, is providing the nest to the Atlantic Ocean, not that 1 acre, but all acres like it. And that without that ecosystem, the planet will fail. Then what's wrong with a 400-foot setback, if that's necessary to protect it?
Well, if you make that case, presumably.
Exactly.
Yeah, presumably the citizens of South Carolina would volunteer to reimburse.
Well, no,
the
citizens of South Carolina can't
who's
do
making
that.
the continuation of their society
There's
possible.
not enough money in the world, that's the practical problem, to reimburse for every acre of salt marsh. I mean, I just have $25 worth. It cost them $10 million for me.
Well, does this private Property Rights Act that you're associated with take other perspectives into consideration? I mean, very often the value of a property rises hugely because of government activity. They built a road or they gave electricity or whatever. Now,
precisely. The eminent domain cases are typically where compensation is paid because a road's being built through property and we need a piece of the property, so you get paid for what's taken and perhaps for the damage to the remainder of the property as well. I'm an advocate of alternative remedies to just pure compensation cases, and the bill that we have pending in the legislature would provide those alternative remedies, such as mitigation or transferable development rights or some other variations of existing law that would allow the property owner to be made whole in another fashion and to protect the public coffers from writing big checks. I mean, that's not the goal of the property owners movement, is to line up to receive money from the government.
At what point does the legislation invoke the rights that you advocate? In other words, if I own a piece of property, say that I've paid $1 million for because I was planning on building some kind of a subdivision there, if you can build one on $1 million worth of property, I don't know. But in any event, suppose that after I bought it, but before I engaged in any acts of development, that is, I had nothing on the ground, the zoning law changed and only certain types of houses were allowed, and therefore the property was no longer worth $1 million, it was worth $800,000. Would I be entitled to compensation or else a relief from the restriction or not?
If in fact that change was made for the public good and you alone had to bear it, then I think you should be compensated.
I should be compensated. How about if it was worth $900,000 instead of $1 million?
Well, there's a point at which all property is going to suffer some indignity without having the benefit of compensation.
What does your law say, though?
The law that we have pending would say it's what the appraiser submits the value at, and if a jury believes that, and the government has the
I
opportunity.
understand that. I don't quarrel with the facts. I'm just saying the facts are, I paid $1 million for it, zoning changed before I'd done anything to develop it, and it's now worth $995,000. Am I entitled to $5,000 under the law?
You may or may not be. It depends on the reason for the change, whether it was for public health and safety
It was.
purposes.
Ms. Brown, let me ask you this. Is a lot of what we're here worrying about something that traces to land speculation? Obviously, it's the speculative temptation that makes possible such enormities as you thinking that. Henry George had a solution to that, you remember, and I still find it very attractive. The rental value of all land belongs to the people, and under the circumstances, land speculation ceases to be tempting. Do you give that any philosophical approval?
Well, we don't think that, I don't think
We only
that
have
somebody
15
should
seconds,
be,
unfortunately.
you should not be paid for speculative value, but if it's reasonably investment backed and you buy a piece of property for a use in the future and the uses around it support that and the properties around it are being used for similar uses, then that becomes a reasonable expected value and not speculative. So that would be compensable.
Thank you, Mr. Robinson. Thank you, Judge Sanders, ladies and gentlemen.
Next week on Firing Line, William F. Buckley Jr. talks about the problems of privacy with Nadine Strawson, president of the American Civil Liberties Union. This program was a Warren Steibel production in association with South Carolina ETV. Funding for Firing Line was made possible by a major grant from the John M. Olin Foundation, Incorporated. Additional support was provided by the Annenberg Foundation and the Friends of Firing Line. For information about a video cassette of this program, write to Firing Line, 2700 Cypress Street, Columbia, South Carolina, 29205, or call 803-799-3449. That's Firing Line, 2700 Cypress Street, Columbia, South Carolina, 29205, or call 803-799-3449.